Welcome back to the courtroom, where the pressure is rising and every choice matters. Today, we walk into the aftermath of a hospital incident that turned into felony charges, addiction struggles, and a judge who speaks with direct, clear honesty. This is not a simple drunk and disorderly case. This is a man facing the results of a long and difficult pattern. As the plea moves forward, everyone in the room prepares for a decision that could shape Caleb's future. Stay with us, because what happens next shows just how close he is to recovery and how close he is to disaster.
All right, this is file number 2528084 FY, People versus Caleb Chance Hapner. That's you, sir?
Yes, sir.
And we've met, but again, I need to identify you for the record. Let's talk about your case. In this matter, the allegation is that you were at the Sturgis Hospital on October 10th. You damaged an IV pump, which was worth more than $1,000. So they're charged with felony malicious destruction of property. They allege that you were also a disorderly person. You were drunk at that place, causing this disturbance as a fourth habitual offender. So theoretically, this episode at the hospital on October 10th could be punishable by up to 20 years imprisonment. That's not likely, but that's the maximum allowable sentence if you were convicted of the first felony count. Mr. O'Bear, what's the plea offer?
Speaking with Mr. Gibson, our office has agreed that the defendant can plead guilty to count 2, drunk and disorderly, with an agreement that he's going to pay any restitution requested for count 1.
All right, drunk and disorderly is a specific statute. It's under the disorderly person statute, 751-67-1E, punishable by up to 90 days in jail and a fine of up to $500. Are you going to plead guilty to that charge?
Yes, sir.
Anybody threaten you to get you to plead to that? You have to speak your answer.
No, Your Honor.
Anybody promise you anything to get you to plead to it?
No.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? You won't have a trial. Do you understand?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by a lawyer. Mr. Gibson is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury did not hold your silence against you, and you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. So let's back up. Did you get picked up by the Sturgis police on October 12th?
Yes, Your Honor.
You were passed out in the bushes somewhere?
I was.
A .318. They have to take you to the hospital at 3:02. So they took you to the hospital. Identified the subject as Caleb Chance Hapner due to having to deal with him multiple times this week. I asked him to take a PVT and it's .318.
Your Honor, the defendant's asking if he can confer with me out in the hallway for a minute.
Yes.
Right here is where the judge draws a line in the sand, and it's not subtle. When a defendant has prior firearm convictions, the court's biggest fear is repetition. That's why the GPS isn't optional, it's a risk management tool. The judge is signaling something bigger to the courtroom. Past behavior isn't just history, it's a prediction. So the question becomes, is this about public safety or punishment? And more importantly, would you trust him in the community without monitoring?
All right, are you ready to proceed?
Yes, Your Honor.
Okay, we were taking a plea to being drunk and disorderly. You were pretty drunk. Do you even remember this?
I remember falling out of the car and my mother was there and she informed me that I tried to walk and run and immediately fell and hit my face. I don't remember that.
Do you remember being at Sturgis Hospital?
There were points that I remember, like when this machine had fallen over, it was kind of like an oh crap moment, you know,
What were you drinking?
liquor.
Yeah, that would do it to get that high. Although I've had people get that high drinking beer, but that's like 25 beers. What kind of liquor were you drinking?
Whiskey,
What kind?
R&R.
Did you mix it with something?
Sometimes,
You just drink it out of the bottle?
sometimes.
Well, last time Judge Pattison gave you 90 days in jail. He had one earlier this year. He gave you 4 days. Last time he gave you 90 days. It goes without saying you have a terrible alcohol problem. It started when you were a kid. We had a couple of MIPs and open intox and that sort of thing before you even turned 21. Now the police are dealing with them on a daily basis for being drunk in the street. In the 90-day case, he does still owe a little bit of money, but he probably doesn't even know it. Judge Pattison just gave him 90 days in jail. So, Mr. Gibson, what do you,
Your Honor, may I just briefly indicate that the defendant just recently graduated from Sacred Heart. He was at the rehab there for, I think, approximately 3 weeks. And he has a doctor that has written a note today that says, with the mental health disorders Mr. Heffner is working on, it is my opinion that rehab would target Mr. Heffner for, the doctor's recommending that his treatment providers are recommending that he go to another rehab that is a 4-month program, or I think a 5-month program at, where is it at?
Guiding, it's in Grand Rapids.
It's in Grand Rapids, and they want him to start that program this week. I believe they want him in a.
This is a rare shift from punishment to rehabilitation. The defense lays out a detailed treatment plan, and suddenly we see the courtroom open its doors to a treatment provider, something that doesn't happen unless the court believes the case warrants deeper intervention. This isn't just a quick rehab pitch. It's a plea for a second chance backed by real, documented progress. And look at the judge. He's listening. He's asking for specifics. He's weighing this carefully. The stakes? Everything. Because the next decision will determine whether Caleb goes to jail or gets one last chance at recovery.
Sense to go from the Sacred Heart and then go immediately into this program. And he does have, someone is here that is one of his treatment providers that would like to speak with the court if the court would be willing to.
Yeah, I'd be willing to hear it. His parents are here and a treatment. Why don't you come up to the podium? Rhonda, is your client here?
She is, and I'm negotiating with Angelique right now about a resolution of that case.
Okay,
She had a driving permit, but she can't find a copy of it, and it expired, it's moved over here.
all right.
I'll be back to update you.
Good morning. Would you state your name?
Lauren Frank.
And you work for Pivotal and you're our liaison at the jail?
Correct.
And you've been doing great service for us. And I thank you for it. I sent a little note to your boss telling him what a good job you were doing.
Thank you.
What do you know about this case?
I encountered this client, his first stay in jail and then his second stay at the 90 days. At 90 days, he voluntarily engaged in treatment with me. We had set a plan, one that resulted in us coming back to jail, but since then he is taking my treatment recommendations very seriously. It was my recommendation that he engage in this 4-month intensive inpatient treatment following his rehab. He has not tried to deviate from that plan. He has not tried to exit that plan in any way. He's been very agreeable and realizes that we are in a state that he has a problem. I encountered him the night of his arrest. He was remorseful and said it was an accident repeatedly, even drunk, and then again while sober. We talked through what needs to happen in order for him to recover and gain sobriety. And he's been very agreeable to that.
Well, that's good to hear, because you're gonna die if you keep doing this. Mr. O'Bear, do you have a thought here?
No, if that program is what's best for him, I support him doing that, so maybe we don't have further criminal contact.
Well, yeah, we keep giving him 90 days in jail and he gets out and then here we go again. So I'm all in favor of this. This is hard to do. A, these programs are expensive, and B, there's waiting lists to get in. And Miss Frank's been working magic to get people eligible and into these programs. So you look good today. Your parents are here. You got a tie on. You look clean cut. When did you have your last drink?
The 10th or the 12th, sorry.
When this
October.
deal went down?
Yes.
How'd you happen to see him the night of his arrest?
Sturgis police called me and asked me to come to the hospital. The moment I got there, they were leaving to bring him back to the jail. So I met them at the jail.
I didn't know you provided 24-hour service,
I
but
attempt to
maybe you didn't
when I
get it.
can.
All right, let's see. How long were you in jail before you bonded out?
3 days.
I went in on Friday, Saturday, Sunday, Monday, and then was
You
released.
got out on the 15th. All right, I'm gonna order 12-month probation, 90 days jail credit 5, leaving 85 days to serve. Of the 90 days order, 85 are deferred. I'm gonna hang the jail over your head. Fine is 0. $75 crime victims' rights, a $50 state minimum fee, $150 attorney fee, and $480 probation oversight fee. We'll reserve on rest. Do we have a figure for restitution?
No.
We'll reserve on that. Let's add that up. Mr. Hapner, what kind of jobs have you done?
I've done construction, mainly. Construction.
Are you
Here comes the turning point. The judge lays down a 12-month probation sentence, 90 days in jail with 85 suspended, and strict conditions that leave no room for relapse. This is the kind of sentence that walks a razor-thin balance, a warning on one side, a lifeline on the other. The judge is clearly done with short-term jail stints that change nothing, but he's also not bluffing. That suspended time is hanging over Caleb like a storm cloud. So here's the big question. Does this structure give him the best shot at recovery, or is the danger of slipping back too high to ignore?
on other medications
I am,
and you're taking them all as prescribed?
yes, Your Honor.
All right, I would like to see you get back on track too. This is a dead end street. All right, as a condition of your probation, no drugs and no alcohol, substance abuse counseling and treatment as directed. Follow instructions from Pivotal when you sign a release. We'll try this. Miss Frank, I really greatly appreciate your service. As I said, we can just keep giving people 90-day jail sentences. Don't solve anything. Although the relapse rate from treatment is also very high, but I think at least we should try it.
Okay, do I have your permission to share your diagnosis? Judge, may I say one more thing?
Yes.
During his 90 days, when he was with me and I could provide the once a week treatment, I did discover something that had been missed in his previous course of treatment. He's given me permission to share. Caleb has OCD, and that's been a driving force for him. And so now that we are treating both conditions, and I have made it protocol to do so wherever he goes, we are now seeing the results of that. I know we are in early stages of recovery, but that makes a big difference. So I'm hopeful that this round of treatment and taking that diagnosis into consideration, he is then getting the appropriate course of treatment.
Very good. You don't need to keep coming seeing me, but this started out, and when you have a predisposition to alcoholism or there is a substance abuse disorder, it starts out with a couple of MIPs and a drunk and disorderly, and then all of a sudden here we are in our adult years, and it has an unhappy ending. Let's take this form right here downstairs to the probation department. It's a condition of your probation, you not drink any alcohol or use any controlled substances, including marijuana, not to get in any other criminal trouble. And you're to comply with all the directives of Pivotal, which includes going into a residential treatment program with intensive inpatient. I think that's a star. This is a problem you're not able to beat. And it gets to the point where almost it's fatal. Certainly, if you fall asleep in the bushes in December, they're going to find you in the morning frozen. That's not an outcome anybody wants. All right, Mr. Elkins, you go downstairs. Ms. Franks, nice to see you in person. Thanks again
Thank
for
you.
all the work you're doing for us.
In the end, the judge made her position unmistakably clear. The defendant's long pattern of violence, firearm misuse, and jail misconduct left no room for leniency. Bond reduction denied. One bond raised to $100,000. And even if he manages to make them, strict GPS monitoring and house arrest will follow. This hearing wasn't just about money, it was about public safety and trust, and the court concluded he had earned neither. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.